Okay, this is about rights of the accused. Fourth, Fifth, Sixth, Seventh, and Eighth Amendments, and how people in the United States, when accused of a crime, are protected by constitutional clauses. I am recording these outside, so you're going to hear a vacuum and a dog in the background, but it is nice outside today, and tomorrow it's supposed to snow, so y'all suck it up and just don't pay attention to what's in the background. Listen to me. Okay. Now, in this country, the government has the burden of proof. The government has to prove that you are guilty of a crime. You are innocent until they can prove, prosecution can prove that you are guilty. So the government collects evidence to build a case against you. And prosecutors are under a lot of pressure to do this. There's a lot of political pressure to solve crimes. There's pressure from their bosses, and police are under pressure to solve crimes. Generally, if you can't find good evidence to solve a crime within 48 hours, you're not going to be able to solve the crime. So there is a lot of heat for cops to do this. Now, that leads us, the people, vulnerable to police forces that might plant evidence, worst case scenario, or might collect evidence in an unconstitutional manner. Now, you have the right to defend yourself once they have built or gotten evidence against you, and you have the right to remain silent. The Supreme Court has used the 14th Amendment and established the selective incorporation doctrine in order to incorporate a lot of these constitutional protections against procedural due process violations, even at the state level. Okay, and we're just going to talk about how the Constitution protects your rights. Now, originally in the Constitution, Article 1, Section 9, the state or the government has to protect your right or writ of habeas corpus, and this is knowing the evidence against you. It's important because you cannot defend your innocence unless you know what evidence the police and prosecution have to try to convince a jury of your peers that you are guilty of a crime. Okay, so what does it mean? Of course, like I said, it's knowing the evidence against you. It allows you to defend yourself properly, and it has been incorporated, okay, which means the state governments also have to give evidence um, that they have uh, that they have against you. They have to give it to your lawyer or yourself so you can defend yourself in a trial. It is the reason why a lot of criminal cases get appealed, is that lawyers or criminals feel like their writ of habeas corpus is being denied because maybe their lawyer didn't get to see all of the evidence that was being used in the case, and that the lawyer was unable to prepare a defense for you because they didn't have the evidence that the prosecutors had. Now, U.S. citizens, regardless of whether you've joined a terrorist organization or not, have writ of habeas corpus. In the court case of Hamadi versus Rumsfeld, U.S. citizens, even enemy combatants, and in this case it was a guy who had uh, joined the Taliban and had fought against American troops in Afghanistan. Even enemy combatants have due process rights and writ of habeas corpus. Okay, here's some political cartoons or Stu's Views cartoons about your rights of the accused. So, like that one, I can't defend myself. I need an appointed counsel. And yet you've gotten your case all the way to the Supreme Court. That's ironic. That's referring to Gideon versus Wainwright. Okay, this one, they used my confession against me. I totally didn't see that coming. Alright, that's about how you don't have to incriminate yourself, or basically that's your Fifth Amendment protection to remain silent. And I don't care if your conviction was overturned. Up here, we don't follow the exclusionary rule. The exclusionary rule is a rule that was established in a court case that protects any illegally obtained evidence from being held against you in a court of law. Now, with that being said, let's move to Fourth Amendment search and seizure. Search and seizure means the cops looking in your private property and taking it to use as evidence against you. Now, the Fourth Amendment states that you have the right to be secure in your person's papers and effects. Okay, and you have the right to be secure in these from unreasonable searches and seizures. So, what does unreasonable mean? Unreasonable would be unjustified searches, where there's really no real cause or reason. One thing that the United States government can't do is just go through a neighborhood that has like a high crime rate, or even a city or local police force can't just go through a neighborhood with a high crime rate and just search house to house to house to house. All right, they have to have justified reasons. They have to have a cause to go into those homes. We were talking about DC versus Heller, and how that in that case the family had a handgun because their neighbors were crack dealers, and somebody said, why didn't they just call the police and the police take care of it? Well, the police can't just go on a phone call and search somebody's house. They have to have a good reason to get a search warrant in order to be able to make the search. So that leads us to probable cause. All right. Probable cause. Police and investigators can't search property without a search warrant. That search warrant has to be issued by a court official, and in order to get that warrant, the police have to explain the reason behind the search. What evidence will appear if you do search this person's house? And what evidence might be destroyed if the search is not done now? So you have to have a really good reason in order for that court official. You can't just say, well, we have a hunch. Hunches don't work. You'd have to, as a cop, you'd have to be like, look, we are on a stakeout. We saw this and this and this and this behavior. We've had a lot of complaints of a lot of people moving in and out of the house from the neighbors. So they got to have a good reason. Okay, once you get the search warrant, all right, so you can't search somebody without one. Okay. The police may only search the places that are listed in the warrant, and technically they're only supposed to take the items that are listed in the warrant. And if there's something like during the search that they find, let's say they go into a criminal's house, they're looking for massive amounts of drugs, and instead they find a legal weapons arsenal. All right, they can't technically take those weapons without obtaining another search warrant for those weapons. Okay. Now, if the police take something that is not listed in the search warrant, or let's say my garage is detached from my house and the cops only have the right to look at my house, and then they go into the garage and they find the illegal stuff, but they didn't have the garage listed on the search warrant. Okay. If they violate that search warrant, they're violating procedural due process. Now, there is a rule for all of this. It's the exclusionary rule. It was established in a court case of Mapp versus Ohio. If the police violate this procedural due process and seize evidence that's not on the search warrant, or search buildings that aren't listed on the search warrant, that evidence collected cannot be, or that item collected cannot be admitted as evidence in the trial. It is excluded from being used. So that is the exclusionary rule. If evidence is illegally obtained, it is excluded from being used as evidence in a trial. The exclusionary rule will prevent prosecutors from using evidence acquired through unreasonable search and seizures. Okay, and this rule was applied to the federal courts to federal court cases in 1911. But in the case of Mapp versus Ohio in 1961, the exclusionary rule was applied to state and local police forces as well. Now that was great. You were protected from being illegally searched, but sometimes bad guys are going to go free because of the exclusionary rule. If a cop finds something in somebody's house and takes it, and of course they're trained to follow the rules, but if they take it because they think it's going to be an immediate threat and they didn't get a search warrant, then there's a chance that that bad person can get away with their crime. And what it was accused of doing, the exclusionary rule is accused of handcuffing the cops. So critics of the exclusionary rule says that it makes the police's job more difficult and that criminals can be set free. And what we're creating is fruit of the poisonous tree. So we're creating a bigger problem, and we're allowing criminals to continue to conduct criminal activity without worrying about repercussions, because they can always say that the evidence, or they can try to say the evidence was illegally obtained. Now, in the 1980s, we actually go more on good faith. In the 1980s, the court started to narrow the scope of the exclusionary rule, which allows for convictions in situations when the cops thought they were following a search warrant. So if you were a part of a SWAT team, maybe you didn't actually see the search warrant word for word. The leader of the SWAT team says, all right, we're going to go into this crack house, and we're looking for this, this, and this. There could be a kid in there, and expect there to be, expect there to be people with weapons, dangerous people ready to shoot you. And then, so you're on a SWAT team, that's what you're thinking about. You get into that crack house, and you find other stuff that's illegal too. Right, and you're not supposed to do anything about it? Well, no. In the 1980s, the court said that the cops do have the ability to rely on good faith. Chances are, if you're going in to somebody's home and they're doing something illegal, and there's one illegal thing there, you're really not invading their privacy by finding the other illegal thing there either. At home, you have more protection over your privacy. Without consent, the police may not search without a warrant, but in public, you can harm others, so the police can search you based on erratic behavior alone. And always remember that any evidence in plain sight, whether it's in your home or in your car or on your person, can be confiscated. And the U.S. Patriot Act expanded the government's right to investigate people who are suspected of terrorism without any warrants or without any warrants, and they can wiretap your phone without a warrant too. And you remember, there's been a big thing about the NSA tapping and listening into phone records without warrants, or collecting phone records. Alright, here's your major cases about the Fourth Amendment. Mapp v. Ohio established the exclusionary rule and applied it to the states. That is one noisy bird. Katz versus the U.S. That was about whether the U.S. agency could tap your phone without a warrant, and it was determined they could. Nix versus Williams. The court allows for inevitable discovery. It's kind of like good faith, but inevitable discovery is, if you're a cop and you find out something about a crime, but you may not have had a search warrant, or may not have read a accused person their rights, it's inevitable that you were going to find the information so it can be used. And U.S. versus Leon, this is where the court applied good faith, but the cops do have, as long as they're proceeding with a search warrant and they find something else, they're acting in good faith when they seize it.